Hello and welcome to the program. A hearing in the case of Ukraine against Russia has started on June 10th at the Permanent Court of Arbitration in The Hague. Now, first Russia presented its arguments, trying to convince the judges that the case is outside the court's jurisdiction. The next day it was Ukraine's turn to present its evidences and counter-arguments. Now, Kyiv is asking the court to confirm Ukraine's rights as a coastal state and to oblige Russia to stop its illegal actions like the abduction of energy and fish resources, blocking the movement of ships in the Black Sea and the Sea of Azov, and illegal construction of the Kerch bridge. Now, it's a lot, and to discuss this, we're joined in the studio today by Kateryna Busol. She's a lawyer at Global Rights Compliance. Hello, and thank you for joining us.
Hello, thank you for having me. I think we agreed to speak just a bit of another case, about the case at the International Court of Justice.
Mm-hmm. Yes, indeed. It's happening right now. Now, when Ukraine is expected to have this judgment?
Unfortunately, the International Court of Justice, as the principal and only judicial body of the UN, is loaded with work, and it doesn't have the exact timeline for the proceedings. Usually, it's 4 to 5 years at best, just because Ukraine has many stages in this particular proceedings. We had the preliminary objections case, then a preliminary measures case. Currently, we have the objections to the jurisdiction, and then if we are successful and the court considers that it has jurisdiction to proceed with the two conventions that Ukraine has asked it to look at, the Convention on the Elimination of All Forms of Racial Discrimination and the Convention on the suppression of funding of terrorism, then there will be the actual merits stage. So it's going to take a couple of years more, at least. So without
getting too technical, I'm not an expert in law here, but could it be considered like the preliminary stages towards the real verdict here?
It is a very important procedural stage where the court basically has to answer whether it has the right to consider the present case. So, of course, it's crucial to basically considering then the further facts and details of alleged violations concerned allegedly with the persecution and different violations against the Crimean Tatars and Ukrainians in Crimea, and with the alleged terrorist acts conducted by the armed groups as supported by Russia financially, including in Donbass.
Now, what are the arguments in favor of Ukraine here? What kind of Ukraine did gather a lot of evidence that Russia's presence and Russia's financing of alleged financing terrorism, but what are the arguments in general in favor of Ukraine?
Well, at the present stage, Ukraine had to convince the court that it had the jurisdiction. So therefore, for instance, in the case of the Convention on the Elimination of All Forms of Racial Discrimination, Ukraine has to demonstrate that it has exhausted all the pre-trial conditions that basically allow the court to exercise the jurisdiction over Russia in this particular case. And there is currently, of course, a very interesting, not just legal, but also language debate, because this convention says that the court has jurisdiction when the parties have exhausted the negotiations, when they have negotiated and haven't come to a conclusion, to a solution, or they have availed of the services of the Committee on the Elimination of Racial Discrimination. And Russia is currently trying to say that this "or" means "and" cumulatively. So Ukraine had to go both with the negotiations and also with the committee, which it didn't. And if Ukraine, of course, says that "or" means "or," meaning that these variants are alternative, and that as it has conducted a round of, I think, 7 or something negotiations which haven't been successful, then it could proceed to the court. So currently the court will have to pronounce on that issue, for instance.
So then who decides that these means have been exhausted and this exhaustion of means at the end of the day?
In relation to this particular convention, there hasn't been any such judgment of the court. So basically, these 15 judges will have to decide. They will look at the draft and history of the convention. They will look at the work of the committee under the convention, and they will have to decide whether these two conditions were alternative or cumulative. I must say that Ukraine, in the public hearings that happened last week, Ukraine stressed that, for instance, this committee, the CERT, so-called CERT committee, it wasn't particularly active in terms of receiving and resolving the alleged disputes between states. So Ukraine says currently the committee has about 3 interstate disputes, and it has recently commented that they have such difficulty and also, well, impact, realpolitik impact, that they wouldn't really pronounce like a decision, that they rather could organize the negotiations with respect to those disputes submitted by states. So Ukraine's argument currently is that first, the Convention on the Elimination of Racial Discrimination does not require both conditions to be met, first, and second, that such a requirement would really contravene the essence of the Convention, because if you have such lengthy consideration by the committee, and when we have such, well, alleged mass violations, human rights violations in Crimea, it's not going to help to help the people on the ground in Crimea. So therefore Ukraine said that they conducted as effective negotiations as possible and proceeded to the court. But of course it's up to the court to assess whether the criteria are cumulative or alternative.
Now you used an interesting word here, the word politic. How politic is this court, and how involved in politics, and how can politic influence, I mean real politic influence, the court and the decision of the court here?
Well, as a lawyer and also on the basis of the statute of the court, of course I would say that there is no any political instrument that may have its influence on the decision making within the court. But of course the judges are very cautious in how they interpret international law, because you can imagine they receive the cases about the conventions that haven't been adjudicated yet. So of course their pronouncement on the interpretation of the convention is going to have a huge impact for future cases. And although the decisions of the court, the judgments are bound only with respect to a particular case, of course we understand that interpretation, the views of the judges will be important later.
Because they will refer to this
sure,
later.
Sure, to the judgments of their predecessors. So I would say they take a very cautious approach first. Second, of course we know that, well, any conflict involving a huge superpower like Russia, US, Israel is being treated very controversially internationally. And of course, I think even given the previous judgments of the court as regards the US, for instance, or as regards Israel, and there was an advisory opinion concerning the occupied territories, it is quite cautious. So the best approach Ukraine can have, and it seems that this approach has improved with this stage as compared to the first stage that we have, is of course to base the position on facts. And Ukraine refers a lot to the reports of the UN Human Rights Monitoring Mission in Ukraine and similar very authoritative organizations. So if the legal arguments are based on these solid facts, hopefully we'll have a positive pronouncement with respect to Crimea. With respect to the terrorism issues that Ukraine has concerning Donbass, it's also quite tricky because there has been no adjudication on that particular convention, and because the terrorist acts, according to Ukraine, are happening parallel to an armed conflict. Russia says that these are the ordinary armed conflict violations, and Ukraine says no, these terrorist acts are happening parallel to armed conflict violations, to war crimes, for instance. And of course this is the issue again of the facts and of the legal elegance of proving that, and we'll see how we are successful.
Now the devil is in the details, apparently, but Russia has been involved, as you said, at least to present this argument that the court is not in the jurisdiction of the court. How do you explain that Russia is a bit maybe more involved in this process than others, for example, other court where Russia just didn't even bother to show up.
To appear.
Yeah, to appear, yeah.
It's a good question. I think it's also a mark of respect because, well, it's not just an arbitration tribunal. This is the principal, the only judicial body of the UN. And as I'm saying, just because there is such a lack of jurisprudence on the issues, especially on the terrorism issues that Ukraine is arguing, I think Russia would really want to have a successful international law case against Ukraine, unfortunately. So I think it's a tricky game for both sides. And if one looks at the legal team that Russia employs, one can see that they have been preparing very solidly.
Well, thank you very much for this overview of this complicated case. We'll closely follow it. And thank you for shedding light on all these technical details. It was a pleasure to have you in the studio today.
Thank you for having me.
That was Kateryna Busol. She's a lawyer at Global Rights Compliance. Thank you for watching the program and stay tuned for the rest.